This is Michael Popok, and by the lighting, you know it's legal AF after dark. Let me set the stage. Donald Trump and his long red tie, Jack Smith and his roguish looks come together in one courtroom. Two people enter, one leaves. No, that's a different movie, but I'm talking about legal AF. We're talking about Judge Cannon holding a long half-day hearing on all sorts of important issues at the intersection of law and politics, including motions to dismiss, motions to preclude evidence, motions related to trial with Judge Cannon. What could go wrong? Well, we break it down for you, our most recent episode of Legal AF. Take a listen.
Well, we started off this episode in New York, and now we're heading south to the Southern District of Florida. Let's talk about what went down in the hearing on Friday before Judge Aileen Cannon. This was a hearing that had been scheduled for a little bit of time right now, and the purpose of it was a trial-setting conference. Technically, the trial was already set for May 20th of 2024, but as we've been discussing, that was never a realistic date where Judge Aileen Cannon had not even set normal CIPA deadlines under the Classified Information Procedures Act that one would expect in a case involving classified information. Last week, or about a week and a half ago, Donald Trump had for the very first time, filed the motions to dismiss the indictment, 10 of them, each of them 25 pages or so each, or the limit was allowed to be about 25 pages or so. So it took Judge Aileen Cannon months and months to be able to rule on very basic things. And so how long is it going to take her to rule on dispositive motions to dismiss when she couldn't even make basic scheduling decisions about CIPA? That's why I'm there's no way this May date is happening. Special Counsel Jack Smith requested that the trial date start on July 8th. Donald Trump's briefing before this hearing said that he doesn't think there should be trial in 2024, but Donald Trump suggested that trial take place in August, and specifically, suggests that there be, if you look at this schedule that Trump puts right there, commence in court voir dire and trial. Trump and De Oliveira, August 12th, 2024. So it says it there. But then, of course, during oral argument, Donald Trump's lawyers, or during their discussions with the court on Friday, Trump's lawyers said, yeah, we just wanted that as a placeholder. We didn't really mean August 12th. I know a lot of people out there were saying, really, Trump wants this trial date in August 2024. And I think Judge Aileen Cannon wanted a test if Trump's lawyers really wanted that date, or if they were just kind of putting it there, because she probably would have given it to them, knowing Judge Aileen Cannon, if that's the date they wanted. And then Trump's lawyers yeah, we just put that in the filing. We don't really mean that. We'll set this thing for later in 2025. Popok, break down what happened. And there was a surprise, if you will, that happened there when Special Counsel Jack Smith's team stated a position that we hadn't heard from them articulated publicly yet. And we also learned a little more information about the amount of witnesses that are expected. Take us through what went down, Michael Popok.
Yeah, well, let's set the stage here for this little theater in a courtroom. Jack Smith's there. He's not arguing, but he's in the courtroom. His team, led by Jay Bratt, one of his other lawyers, is the lead prosecutors for the case. Donald Trump there. He was there for that as well. Showed up with his lawyer, primarily led by Todd Blanche. And we had Judge Aileen Cannon, who was appointed by Donald Trump, who, for those that are just tuning in for the first time to Legal AF, she already got sideways with her bosses at the 11th Circuit before the indictment even came out at Lago, and got slapped twice, not once, but twice, for doing inappropriate things as a trial judge. Question is third time the charm? We'll talk about that issue that came up during the hearing. The troubling thing about the 60-day rule DOJ internal policy discussion is that it came up because Aileen Cannon, the judge, raised it and said, well, what about does the 60-day Department of Justice internal handbook that there will be no investigations within 60 days of a election because of election interference concerns, public policy concerns. Does that apply here? Well, obviously it doesn't. I mean, we just read the language of the DOJ manual. You know, it only applies to existing investigations and not to ones that are already up and running. But they never had that sort of clarification there. So in response, the lawyers that represent the government, the Department of Justice, Special Counsel's Office, said it doesn't apply. It doesn't apply because we're not starting an investigation or an indictment. We're beyond that. The person's already been indicted, and it doesn't mean we can't continue a case all the way through trial and verdict because it's within 60 days of an election. But the fact that she even brought it up, I thought was slightly troubling. It was, to those that were in the room, and again, unlike what you and I are going to talk about in the Fawny Willis, Fulton County, where everything's on YouTube, including on the MeidasTouch network. Nothing in federal court is on YouTube, MeidasTouch network, or anything. We either have to have people in the room that give us that information and that we trust based on past credibility. And we know certain people that are in the room in our legal political world that report, like Hugo Lowell for The Guardian that we just posted there. And there's others that we like as well. And so we know what went on in there. It was combative against the prosecution team. Most of the firepower was being trained by the judge, not on Trump's team, but on the Department of Justice and special prosecutor. Now, look, she's not the only federal judge that sometimes holds the prosecution's feet to the fire. We are in a system of justice where the defense is presumed innocent, the defendant is presumed innocent until proven guilty, and the prosecution has to meet its burden. And sometimes judges take that to an extreme. But coupled with all her other prior rulings and weird ways of managing, and that's a heavy lift in that sentence, the word managing this case till now, it's a bad look. And it got even Jack Smith concerned, because the reporting in the room is he almost fell out of his chair, eyebrows raised and almost aghast when they got to the issue. There were a number of issues at this multiple hour hearing. One was the trial setting that you just talked about, but it was also about a motion for reconsideration hearing because the government is convinced that Aileen Cannon has royally screwed up. That's a legal term. We sometimes refer to it as clear error or reversible error, a major decision about the identity of witnesses that should be kept confidential and secret for now, including ones that are grand jury witnesses, revealed only to the defense who needs it to defend their case, but not to the public and not on a public docket. And they pointed out to the judge in their motion for reconsideration with big red letters radioactively glowing that said, clear error, you're not applying the right standard. Even the case law judge you cited in your own order is you're not applying the right, you're holding us to a higher standard than what we have to prove that the witnesses should not be disclosed in the public docket because they could get doxxed, swatted, attacked, and everybody in and around cases involving Donald Trump have had that happen to them. Aileen Cannon has had an assassination threat made to her. Every judge has. Merchan, Chutkin, I don't know about McAfee. I haven't heard that one. All the prosecutors have death threats, all of them, all the Attorney General of New York, all of them, and staff and jurors and grand jurors and the rest. And so that's already well documented. It's an immutable fact that if you're involved, if you're somehow connected to the justice system and Donald Trump, you are going to be violently, and persistently attacked by Donald Trump and those around him. And so that's like a no-brainer. And yet she pushed back and doubled down again at this hearing. I thought she'd see the light and say, "Ooh, I don't want to get reversed the third time from the 11th Circuit." And I'll talk about the lemon law that I think exists in the 11th Circuit about 3 times you're out. And she said, no, I take very seriously my responsibilities to ensure that the public is informed during a criminal trial. And your attack, she didn't say my attack on me, but she got close. She said, she took umbrage that they would accuse her of not understanding the law. And she said, well, I understand the law. In fact, why do you think this law that comes out of the civil context applies here? And they're just rolling their eyes. And that's where Jack Smith is reported to almost fell out of his chair about her taking this position. But there is a silver lining. And based on what she did during the hot bench, if she makes this major clear error, which they've also called manifest injustice, they are taking a direct appeal to the 11th Circuit, and it's going to be, there she goes again. Here we are. And if they get, for instance, the Chief Judge William Pryor again, who was on one of her panels that shot her down the first time, and say, Judge, judges, what are we supposed to do? Okay, she's not only made a series of reversible errors about an incredibly important case to our justice system and to democracy, including at the beginning of the case, before even the indictment. I mean, before the case was a case, she was making inappropriate things that got reversed. And now look what she's doing. And then you can point to all the other things. Like, why are we talking about motions to dismiss indictments a month before trial? Why aren't we talking about that 8 months ago and 9 months ago to give time for the case to actually occur? And there's another body of law, Ben, in 11th Circuit and other courts too, that talk about a judge effectively painting themselves into a corner and then having to defend themselves and feeling put upon by the prosecution. It's either referred to as a stalemate or painting themselves into a corner. And she's painted herself into a corner with a series of weird decisions that she's now doubling down on. And that, hopefully, the 11th Circuit, when Jack Smith has this opportunity, he can say, look, she needs to go. And they have the power as administrators of all things within the 11th Circuit, including in Florida, to remove her and replace her. And now I would think would be the time, especially, and I'll leave it on this one, and maybe you can turn, Ben, to the witnesses that were disclosed, the amount of witnesses disclosed by the federal government here. But the trial setting, take May off the board. We don't blow smoke or sunshine here. May is not happening. The question is whether it's going to happen at all before the election. And what they're doing, and I'll give them a little bit of credit here. It's evil genius by the Trump side. They say, well, we got a judge we can kind of lead to error. So why don't we use her here? Have her sit on the calendar in August and continue to box out like she's rebounding all the other cases. Because and we'll get to the Supreme Court later in the podcast, if somehow the Supreme Court immunity decision gets made fast enough and Judge Chutkan can slide a case in July or August, she won't be able to, because Aileen Cannon will be sitting on that date, and neither will McAfee in Georgia. So, and then she'll say, oh, when August comes, I can't do August. And now they haven't been preparing for the other cases, so they'll argue due process violation. We don't have time. And that's what we're doing here, because she's never going to try this case before. She doesn't want to try the case before November, and she's not going to try this case before November, but she's not going to let us officially know that until it's too late to reset the rest, unless the 11th Circuit intervenes and takes her off the case.
I think the 11th Circuit is going to do that. I think this is all kind of coming to a head right now with the fact that she actually has to make rulings. One of those rulings is the most basic one, where she wanted in the courtroom. She tried to get Special Counsel Jack Smith's team to list all of the witnesses that they were going to call, including ones that for now are confidential witnesses and potentially confidential informants, where you would never disclose it at this phase. Special Counsel Jack Smith's team did say the number is around 40 witnesses, but that's not the type of thing that's disclosed publicly at this stage. It's not like Donald Trump doesn't know about who those witnesses are. He does, because those are turned over pursuant to the protective order in the case. But the issue is that it's only a good cause standard for the government to say we're not disclosing witness reports publicly yet, and witness interviews and the identities of confidential informants. The whole reason that you have a protective order in discovery is that you need to protect this exact type of situation. So what Trump's lawyers had tried to do was say, okay, well, maybe that's the good cause standard for discovery, but what if we just file a bunch of frivolous motions to compel, and then attach to the motions to compel all of that discovery that you turned over, and now we're going to say, aha, now the public should get access to it because we're putting it on the public docket. And Judge Aileen Cannon bought into that logic, and she's like, well, that seems to make sense to me. And then Special Counsel Jack Smith responded, that's not the law. Just because you take the confidential discovery and you try to throw it on a public docket, it doesn't change the standard that we, the government, have a good cause basis to keep this stuff confidential. So I think she's going to make an error there, because she seems to be inclined to do so. I also think she's going to make an error when it comes to not allowing the government under CIPA Section 4 to withhold certain types of classified information. We're not talking about confidential now. We're talking about the classified information and provide substitutions. For example, the government doesn't want to turn over the actual war plans themselves or the nuclear data to Donald Trump. Instead, they want to turn over this, a substitution or a summary. This involves nuclear, codes or nuclear information specifically that relates to this, but not the underlying data. Or this relates to war plans and you kind of summarize it. What Judge Eileen Cannon did last week, and many people were saying, oh, is Judge Eileen Cannon actually ruling against Donald Trump? Because Judge Eileen Cannon rejected Donald Trump's request to access the CIPA Section 4 filings themselves, and which a criminal defendant never gets access to. So she was rejecting something that under the law, it's never happened ever, the same way she tried to assert back in 2022 equitable jurisdiction over a search warrant that a magistrate judge grants, which never happened ever. But if you actually look at her order, what seems to be what her plan was, remember how she set all of those ping pong hearings? First, let me get this session. Then I'm going to have this session with the government. Then let me bring Trump's lawyers in. Then let me bring the government in again. For all purposes, she basically gave Trump what he wanted by having all of those hearings over and over again, which are not supposed to take place in general, these kind of pre-CIPA Section 4 hearings. But notice what she says in her order rejecting Donald Trump's access to the filings. She's not rejecting Donald Trump's eventual access to the documents. She's just saying you can't see the filings. But she says here that as best the court can discern, following its rigorous analysis, defendants' rights will not be impaired by today's ruling. In other words, she's saying there she's looking out for Donald Trump. I mean, that's why it's important that we show you what these documents are actually saying. So my prediction is she ends up showing Donald Trump these CIPA Section 4 documents. Jack Smith appeals to the 11th Circuit, and I think all of that happens in the next 60 days. And ultimately, I think if she sets an August trial date, because all of these appeals to the 11th Circuit will be interlocutory, I think they will stay the proceedings that will be taking place before Cannon, and I think that August date's going to be kicked. That 60-day rule is an interesting one, Popok, because I could see Special Counsel Jack Smith saying, okay, Supreme Court, you want to take this up in, we're going to talk about this in a little bit, the Washington, D.C. Trump absolute immunity claim. You want to take that up on April 22nd? Bet. Okay, you do that. But when we get the ruling in May, we're going to tell Cannon that we want the trial in October. We don't care. You're the reason that it delayed. Trump's the reason it delayed. We're going to try the case when the case is ready.
Well, if you like podcasts hosted by lawyers who know what they're talking about at the intersection of law and politics, you've come to the right place, and only the right place, the MeidasTouch Network and Legal AF. We do that type of analysis and that type of thing twice a week. Wednesdays and Saturdays, 8 p.m. Eastern Time on the MeidasTouch Network. We curate the show that we think you need to know at that intersection of law, politics, and justice. So if you like this show, you know all about it, we welcome you. Thank you for being part of it. Take the clip, pass it along, pass it on. Send it to your friends and family and others in your life and say, hey, you know that podcast I love, Legal AF? Here's an example of it. Maybe they'll join us and become part of our audience. If you don't know what I'm talking about or who I am, I'm Michael Popok. That was a clip from Legal AF. And join us Wednesdays and Saturdays, 8 p.m. Eastern Time on this MeidasTouch YouTube channel. And while you're here, don't change that dial. Help them get to 3 million free subscribers on their YouTube channel, because we have no outside investors. We've got we're just completely grassroots. We are you. You are the change you've been looking for and the network you've been looking for. We call it MeidasTouch. So until my next hot take, until my next Legal AF, this is Michael Popok reporting.
Love this video? Make sure you stay up to date on the latest breaking news and all things Meidas by signing up to the MeidasTouch newsletter at MeidasTouch.com/newsletter.